counseling conference. It was set on the request of the defendant, who asserts that there's a dispute between the parties regarding the contractual buyout amount, and that hopefully the setting of this conference could save some motion practice and resolve the dispute. So I'm all ears, Mr. Bradway.
Thank you, Your Honor. And just because I know it was not briefed as part of the TRO process, the operating agreement that we discussed heavily contains a provision that allows the company to buy out the preferred member at any given point. A couple caveats to that. If there's a triggering date, MGG is paid all amounts due and owing under the operating agreement. It requires the company, Phoenix Tallow, to send notice to MGG that they are exercising that option. That notice was emailed yesterday as well as sent via FedEx overnight, consistent with the notice provision. Utilizing today as a triggering date, payment will be made within 5 business days to MGG. Just as a result of kind of the material change in MGG's interest in Phoenix Tallow, given that they will not have an interest once they are bought out, we just felt it was appropriate to inform the court of this development, which may materially alter the claims, whether it moves forward, discovery in some fashion if it does move forward, but really just wanted to apprise the court of this update.
Okay, and what are you asking the court to do, if anything?
We're not asking anything at this time. To the extent a dispute arises between the parties about the company's election of this buyout, we may be submitting an additional request to address any perceived issues. But at this time, we just wanted to inform the court of this update, given that within this week, next time, MGG will have no interest in the company.
Okay, Mr. Purcell, is there anything that you wish to address?
The only thing that I would add, Your Honor, is we will be responding to the notice, taking the position that the company gets to execute 5.7 in the buyout, not the former manager or the common members. We don't think it's appropriate. That being said, our clients are all in favor of this going forward, and we intend to cooperate, assuming that they've got the money and we can get this thing resolved. As a matter of fact, I haven't yet this morning reached out to opposing counsel, but I think we ought to have a call as soon as we get off this call to discuss the logistics of that.
Okay. Well, it sounds like this may be a positive development then, that it takes care of getting the plaintiff paid off and resolves the case. So hopefully that will happen. So I don't know, what you would need from the court, if there'll be a notice of settlement being filed at some point in time, or what will happen. But I'll await further developments and set further hearings as needed. But it sounds like right now there's no action for the court to take.
That's correct, Your Honor. We just wanted to inform you of the update and counsel what we can connect after this.
Okay, perfect. Great. Thank you, everybody. Have a good day.
Thank you, Your Honor. You do the same.